morning everyone, my name is Robert Muscat. I'm just been elected as President of the Military History Society of New South Wales, and welcome to our first lecture for the year of 2022. I'm hoping that it'll be good to us and we won't have any lockdowns, and I mean that we can gather here every month, every first Saturday of each month, and you're again the most welcome to attend throughout the year. This morning I have the pleasure of introducing our speaker, James Humphreys. Before I do that, we're privileged today to have our patron here with us, Justice Paul Brereton. Thank you, Paul, for being here this morning. Really appreciate your support. James Humphreys is a civilian lawyer, Commander of the Royal Australian Naval Reserve, and a former Military Reserve legal officer. He began researching the Breaker case in 2009 and had serious misgivings about the legality of the trials of Morant, Handcock and Witton. James has conducted significant research into the Morant case. His work has included petitioning the British and Australian governments, and in 2018 he succeeded in securing a motion in the Australian House of Representatives that provided an apology to the descendants of these men, an expression of sincere regret they were not tried according to the law of 1902 and suffered a fatal injustice. His work continues to secure posthumous pardons for the descendants of Morant, Handcock and Witton. He's been involved in documentaries and many media appearances. He's also the author of numerous articles on the Morant matter and of the book Ready, Aim, Fire, Major James Francis Thomas, the fourth victim in the execution of Harry Morant, published 2019. On the flyer that was sent out, there's also a link to James' email if you wish to contact him directly. I now ask James to come forward and to present his lecture. Thanks, James.
Thank you for that kind introduction and welcome, and it's a privilege to address the group. I follow with great interest any social media sites to do with military history, and I'm a member of quite a few of them. This one stands out for me, of course, because Lieutenant Handcock came from Bathurst, went to the Boer War. Lieutenant Witton from Victoria, and Breaker from all sorts of places, but predominantly South Australia. I'm very pleased to say that Richard Williams, to my left, to the right, Richard's great grandson of Lieutenant Handcock, and Beach Thomas comes from Sydney, a great nephew of Major Thomas. I suppose happy to take questions or comments, interjections, protests as we work through a few of these slides. I'm conscious of death by slides, so I'd like the open the floor to whatever you're thinking, because I suck up all this information. Last year I applied to go on the ABC Hard Quiz. As my wife says, it's the only thing that I'm breaking around that I've got a photographic memory about. As far as doing stuff around the house, I forget it like everybody else. So fingers crossed I might get a Guernsey on Hard Quiz. I'd like to give Tom a bit of a hard time. Look, when I was living in Canberra, I was living at Duntroon, and I was the only Navy person there, and the Army guys wouldn't talk to me. So I thought, what am I going to do for an hour and a half, year and a half while I'm in Canberra? And believe it or not, I was watching the Breaker Morant film one night, and I thought, oh, this is interesting. I was intrigued by Major Thomas and his history, of which there was very little. He gets mentioned on the War Memorial, and of course up at around about on a few articles on the internet, but I discovered to my dismay that Major Thomas, who joined the Boer War as a captain, took over troops, volunteers, was a solicitor from Tenterfield, went over as an infantry officer, and it's quite an extraordinary story. You know, he's over there thousands of miles from Australia, and command and say, look, we want to appoint you to defend or represent three of your countrymen. No support, no solicitors to help him. Prosecution had unlimited resources, and while these three men were in solitary confinement, denied any form of legal representation during that period, leading up to the investigation and then the trials, no contact with Australia, with their relatives, which was a clear breach of itself of procedures and protocols under military law at the time. So I took an interest in Major Thomas, and aside from doing this case, I've really tried to derive some recognition of his place in history, and that's why I wrote the book about Major Thomas, a man who suffered greatly from his experiences as an advocate. Died in 1942, and broken, destitute, bankrupt, struck off the rolls in New South Wales. The list goes on. He, in some ways, ended up as, this is my terminology, but the village idiot in Tenterfield, broken and alone. And when he did die, he died from malnutrition and very much alone on the outskirts of Tenterfield on one of his properties. So that's a sort of a sideshow for me about Thomas. The other, the main event, I'm not here, and some people misconstrue what my advocacy is. I'm not here to support war crimes. I've done too much military service, particularly in military law. I well understand and appreciate and have practiced the law relating to war crimes. In the modern era, this is 1902, not post-World War II. And my barrow, if you like, is not about excusing war crimes if indeed these men are guilty or were guilty of war crimes. They admitted to the shootings. What my quest is, they were not tried according to law. Now, amazingly, we find the same parallel that's running around with the SAS inquiries. No one's been charged, and yet we have this stampede of innuendo through media and various television outlets already condemning these men, the SAS troopers. I find that the concept of trial according to law absolutely sacrosanct in our form of democracy. We live in a democracy, not a dictatorship. So what intrigued me about this case was, lots of things have been written about Morant over the years. Lots of, indeed, more recently too, that opinion dressed up as historical fact, or guesstimate dressed up as historical fact. I'm not into guesstimates and opinion and innuendo. I'm into what can be proven. What evidence do you have that they weren't tried according to law? That's what I'm interested in. And there are some fundamental errors that relate to this case. And in the modern era, I'm sure the Commonwealth, Department of Defence of the Commonwealth understand how the SAS troopers will be treated. It's absolutely clear that the rule of law has to be respected. And mindless rumour and speculation undermines that process. The process in 1902 it's just as important in 2022, 120 years after Morant was executed on the 27th of February. Just a bit of an overview of the history of the Boer War. What I find intriguing about the Boer War was it's Australia's first involvement prior to Federation, but certainly post-Federation, serving King and country, Queen and country, King and country. And the call to the colonies was taken up by all the colonies in Australia, and that's how Breaker Morant got involved. And I must say, his service with the South Australian Rifles was exemplary. He got promoted, got a commendation from his CO, unblemished record, unblemished. It's when he goes to England, comes back to South Africa, signs up with Bushveldt Carbineers, a British unit, not a colonial unit. That's where problems occurred for the three of them. Bushveldt Carbineers, a modern form of counter-insurgency, if you like, most sought after by Lord Kitchener. Live off the land, fight the way the Boers fight, ambush and good shots, good horsemen. Lord Kitchener was struggling when he was appointed. His job was to bring this war to an end, sort of reminiscent of Afghanistan in some ways. But he found that they weren't winning. Thousands of British troops just simply couldn't win. Artillery still couldn't beat the Boers. The Boers worked an insurgency like we've seen in modern wars, and very effective, very effective. Little kids running around were spies for the Boers. Families gave logistic support to the Boer fighters who worked as farmers during the day and guerrillas in the evening. So the Bushveldt Carbineers was a unit that Kitchener wanted to use to effect. In fact, he even brought over to South Australia some Aboriginal trackers to help in the fight, do some tracking. And that's another story in itself, because when the war finished, the trackers were left there. Major Thomas, well, an intriguing situation. No court-martial experience, country town solicitor, community figure for sure, a leading figure in Tenterfield at the time. A volunteer, and got the troops, the volunteers from Tenterfield over to South Africa. He was commended in his work as an infantry officer, but then when he was ready to come back to Australia, he was called on to do this job. And for those of us that have worked in the legal system, it can be a pretty tough experience if you're doing it yourself without any form of support. So my book on Major Thomas has tried to unpack who he was, what he did, and how it affected him. Some of the writings that I've really studied carefully are the letters that Thomas wrote to various state premiers after he came back to Australia, in a summary, basically saying that the courts martial was a travesty, a set-up, and probably the most, and I'll come back to talk about this later, the most glaring, appalling situation was that with 18 hours notice, Morant and Handcock were executed. What Thomas tried to do was lodge an appeal. Two levels of appeal, redress of grievance through the military chain of command, a system that still exists today, but also a petition to the King for mercy, to the Crown. Not only was he denied that opportunity, but, well, he was denied the use of the telegraph to alert the government in London as to the predicament of his clients. We can dodge and weave as much as we like about their admission to shooting the Boers. What's not up for debate, though, is the appalling lack of appeal. And, you know, in today's modern world and through the decades, a right of appeal has always been recognised, both in military courts and civilian courts. But certainly, making a push for clemency from the King was on the cards, particularly as in the 4 trials, the 4 courts-martial, the officers of the court did something that didn't really happen in a lot of the trials at the time. Under the Manual of Military Law, they made recommendations for mercy, and I'll come back to those shortly. But the basis of the appeal to the King would have drawn on the recommendations. And under the Manual of Military Law of 1898, the manual states quite clearly that recommendations for mercy are exceptional. They're not run-of-the-mill, it's not a rubber stamp, you have to earn them. And that's what they did earn them. But to deny Thomas that opportunity is an affront to the military system at the time. So we've got the charges. My research has shown, I know some writers have said, well, they shot, Morant shot 20, 30, 40. I only go on the evidence, not speculation. So with respect to Peter Fitzsimons, I don't make stuff up. I look at the charges on the charge sheets. I secured all of that in my early research. The execution of the German missionary Heese is another good example of speculation. That was the one charge that these men were acquitted of. But many writers who claim to be historians say, well, they did it anyway. Well, the court didn't think so, and that's what I go by. I don't go by guesswork or innuendo. The prisoners, I went to South Africa a couple of times. This is not just young youths, children, young men, Boers. Some of these people were operating very effectively against the British. So a 12 or a 13-year-old, and we've seen the same thing in modern warfare, guerrilla warfare in Afghanistan, a 12 or 13-year-old who looks quite innocent is actually feeding information, intel. And that's what happened in the Boer War. So we'll get to the defence side of this shortly. But one thing's for sure, Morant admitted to the shootings. There's been no evidence that I've seen, admissible evidence, to say that they shot 20 or 30. One of the telegrams that Lord Kitchener sent to the Secretary for War after the trials, when he was signing off the death warrants, Lord Kitchener put in a report to say that there were 20 that he killed. But in the same telegram report, Lord Kitchener says they were convicted of the 12. Well, I struggle to say, well, then or now, somebody is guilty of shooting 20, but we can only prove 12. I mean, where does that take us? It doesn't take us anywhere. A court, a jury, a court, makes the decision on the evidence. That's what I'm interested in. So whether it was 20 or 30 or 40, when I went to South Africa, some of the Boer families told me, well, there were dozens. And maybe there were. Morant there was a lot of evidence that I uncovered in archives in Pretoria that there were a number of instances of British soldiers, reports made, British soldiers shooting Boers, and also British soldiers shooting black residents of South Africa who were supporting, some who were supporting the Boers. The article back in 2009 was really to get things underway for the Petitions Committee in the House of Representatives, plus a petition to the Queen. So that got the ball rolling for the British government to have a look at it, and that's what they did. It took them a year and a half, and they came back to me and said that the petition did not uncover compelling new evidence. So a petition denied. The Petitions Committee made up of MPs, including Alex Hawke, for example, who's Minister, had a different view. And so did Robert McClellan, former Labor Attorney General. The committee, after a day's hearing, looking at the evidence, said not that they should be pardoned. That wasn't the focus of my work. My focus is to get an independent inquiry. That's what my focus is. If that leads to for the descendants, a pardon, fine. But the first trend stop for me is to get an independent inquiry, because what I've found going to Britain and dealing with various politicians in Australia, there are lots of political agendas as to why this case should not succeed. And I don't say it's a rubber stamp for a pardon. What I do say is, if you're going to bring this case to a conclusion, bring it to an end, then what's the harm of an independent inquiry? And I'll come to a precedent that I think I've urged the current government. I think it might work. It's a bit of a quote from one of Thomas's letters. Well, he had a hard job. For a fellow who wrote wills and did a bit of probate and deceased estates, going into a confronting trial, 4 of them, would have been very difficult. The shooting of Trooper Van Buren, again, like Heath, difficult to prove. It's not saying it didn't happen, but you make the allegation, you've got to be able to prove it. And they're the outcomes. Now, probably one of the most controversial aspects of war is the obedience to orders. The law at the time provided for reprisal. It has to be endorsed. You can't just sort of run around saying, oh, I'm going to take revenge against the enemy. There is evidence that reprisal was authorised not by Australian volunteers, men that weren't polished in military law and were not full-time military officers, but by British officers. And those orders were reprisal against the Boers for outrages by the Boers against the British, including summary execution, blowing up trains, stripping British soldiers of their uniforms and using those uniforms to deceive the British in the field. At one point in November 1901, Lord Kitchener issued a written declaration that Boers found wearing British khaki would be executed as a way of driving home the view that if you do that sort of thing, you'll be shot. Captain Hunt, Morant's CO, he was attacked and killed by the Boers. Some evidence from the British surgeon that Hunt's body was mutilated. Lots of debate about that, but I simply go off what the evidence I've seen from the British surgeon who examined the body. So up until that point, Morant had refused orders prior to summarily execute Boers. He had a very close relationship with Hunt, and that was the tipping point. So he said, okay, I'll start obeying the orders of reprisal. What I find interesting about Witton's commutation from being executed to life imprisonment, I think, this is just a private view, but I think Kitchener made a big mistake in commuting the sentence, because when Witton came back to Australia, he blabbed and wrote extensively in his book, Scapegoats of the Empire. An eyewitness, Witton, his book provides a lot of insight as to how he and the other two were treated. Picton, a British officer, was treated differently. He was cashiered, wasn't executed or sentenced to life imprisonment. Lenihan, a lawyer from Sydney, reprimanded for failing to report offences. And Captain Taylor, a British officer, also Morant's superior, referred to by the natives in South Africa at the time as guerrilla. Guerrilla was killer. Taylor had a fearsome reputation. He was charged, but acquitted. That's what happens. Okay. Now this part's rather interesting. What I find difficult about the recommendations for mercy, not that they reflect the evidence that was presented at the time. Otherwise, why would they be made? 4 trials, recommendations were significant. What I find curious is that, and this is part of the plea for an investigation, if the recommendations are good enough for Witton and commute his sentence to life imprisonment, what's the difference? Why shouldn't the recommendations be applied to the other two? Given the significant evidence that Morant, with the Hunt murder and torture, acted under some duress, mental duress. In modern lingo, a pretty good mitigation to have a reduced sentence.
Excuse me, could I just interrupt?
Yeah, sure.
Could you clarify whether did the court martial make a recommendation for clemency at the time?
Yeah.
What was that? Because that's a bit
No.
confusing there.
Oh, sorry. Yeah, the
recommendations and observations.
Yeah, the recommendations were made for the 3 of them.
Same one.
Yeah, but cited slightly differently. For example,
Okay, 1 and 2 look like recommendations.
which dot point?
First 2 dot points, are they the recommendations?
Yeah. Extreme provocation.
Yeah.
Yep.
Good service?
Witton's cited as good service record, and the fact that the other 2 were his.
So the first 4 dot points are the recommendations?
Yep.
Okay, thank you.
Yes, sorry, yes. But when you we balance these things up as a separate issue for an investigation, an assessment, is to say, well, why were recommendations made? How were they made? Were they made under military law? They were. Were they applied appropriately? One might say in Witton's case it was, why not the other two? I'll get to a precedent case shortly to say why these things should be considered, not by me, but by an independent authority. Some of the most insightful material in studying this case comes from Witton himself. Some of those who write about this case conveniently ignore, deliberately perhaps, some of the insightful material that Witton came up with in his book. Some years ago I discovered in Canberra, in archives, Witton's request for a copy of the transcripts. I also, he paid a few pounds to get a copy while he was serving a prison in England. And Major Thomas did the same. So both of them had access to the transcripts. But in Witton's case, of course, he had the advantage, he was an eyewitness. Lots of law around reprisal and superior orders. The question to ask, as a general proposition, if the order is illegal, then in a snapshot you can't say, oh well, I got a superior order, therefore I shot people. If the order was blatantly illegal, and that's certainly the standard in the modern era. But in the Boer War, there are some factors that have to be taken into consideration. None of these men received formal military training. They came from Australia, they were volunteers, they were good at living off the land, they were good shots and good horsemen. That's about as far as it went. If they believed in good faith, in their own good faith, and the evidence was, and it comes from Witton, that this is what Handcock and Morant both told the court, that they believed the orders were appropriate because they related to reprisal. A lot of people say, well, it wasn't just reprisal, he just went off in the gallop by his own, on his own volition, to shoot people. Well, I respect people have those opinions, but I haven't found any evidence to that effect. What I have found is evidence relating to these charges that he admitted to. So that's what I'm interested in. With respect to Peter Fitzsimons, I think whoever's done his research for him, I think he's missed the point, and he certainly doesn't understand, in my view, much about the military law at the time. So, for him to say, in so many words, Morant got what he deserved, that's one view of it. But I say that one outrage, even if it was an outrage and illegal, isn't mitigated by another outrage, and that is trial not according to law. Arthur Davey is no longer with us, but did an enormous amount of research on this case, South Africa. And he, in his writings, in his book, he has some, this is my interpretation, but he talks about a bona fide belief that the order is lawful. And you have to take into account, again, we're not talking about, professional soldiers here. You're talking about blokes that got 10 bob a day when Australia was going through coming out of a depression and doing it tough, went off to war to earn some money and have an interesting experience. Now that quote from the Manual of Military Law stands. It's not a requisite to prove the command was given personally, so you don't have to prove that it was personally given by Kitchener. The suspicion is that it was, but no one's produced a document signed by Kitchener. But what we do have, Colonel Sinclair, a legal officer of the British military, former barrister, was on command staff in South Africa to review trials. That was his job. A very experienced lawyer. And during the investigation of these offences, Colonel Sinclair wrote an opinion about the evidence that he had reviewed. And he identifies the British officers who gave the orders. Captains Hunt and Taylor. So if Morant says, well, I was given orders, reprisal by Hunt and or Taylor, he doesn't have to prove that it came directly from Kitchener. These guys worked under military law at the time. Refusal to obey an order was a capital offence. A couple of Witton's quotes as to how they conducted themselves. That's his view of it. That reflects his evidence that he gave at the trials. So as we go along, again, to repeat what I said earlier, I'm not saying that this is an argument of itself, what's been presented so far for Apostles' Pardon. What I say is that this material raises the question that an independent assessment should be done. Now, some of these subsections of the Manual of Military Law had direct relevance to the case for investigation. Failure to give the prisoner full opportunity of preparing his defence and free communications with others for the purpose may invalidate the proceedings. Well, basically that's what happened. The three men locked up solitary confinement while the prosecution had 3 months to prepare their case, unlimited resources, no contact by these men with the Australian government under Federation, no contact with their relatives to seek help. In fact, Lieutenant Handcock's wife at the time didn't find out until April 1902 that her husband had been executed. And she had an article in the Bathurst newspaper at the time protesting his treatment. Those three procedures really, in some ways, ring true in the present criminal law jurisdictions. Courts relate to fairness all the time. You've got to give people a fair go. These guys didn't have a fair go. Lieutenant Colonel Gunter wrote extensively about military law. That was his view. Direct quotes. These men they found that a lot of the witnesses that they could have called had been posted out of South Africa during the time that they were locked up. Whereas the prosecution paid for their witnesses to stay in the area so they could be called for the trials. This condemnation thing is really fascinating. You would have seen it portrayed in the movie. Had condemnation been applied for these men being called on to repel an attack by the Boers during one of their trials, condemnation should have been applied. Why wasn't it? I don't know. Is there evidence to say it was even mentioned? No evidence. But it was relevant. Did the officers of the court know about it? Probably, maybe. The prosecutor, Major Bolton, maybe. I'm speculating. What I am saying though is the evidence of these men repelling the attack and being called on and given arms while they were under trial happened. So again, this would be something for an assessment by an inquiry. A quote from Bill Wilmore's book. It's reflected in the movie. The involvement, the principle of condemnation at the time, which doesn't operate in the current era, affords grounds for a pardon. So I say that if an inquiry was held, inquiry officer could review what happened and the rules of procedure according to 1899. How are we going for time? Must be close. 10 minutes? Wow. Fantastic. This quote of mine goes to the very heart of the issue. And I would say, I've said it many times, but people still go onto social media and say I'm accusing war crimes. I'm not. What I've got zero tolerance for is a lack of trial according to due process. So the next time you see it on social media and some of the sites, no, I'm not excusing war crimes. What I have a zero tolerance about is not trial according to law and sentencing. This is sort of a summary. It's all built around fairness. The mantra from some writers that Morant got what he deserved doesn't quite fit with me, I'm afraid. Either in the modern era or back then.
I have a question.
Yeah.
Just on the wider context of this, I mean, they had 600,000 troops in South Africa at this time.
Yeah.
And was this sort of a, you know, they had evidence and they wanted to send a message to the military as a whole to stop this?
Possibly.
Shooting of prisoners?
Yeah, possibly.
I mean, is this unusual, this trial, or were they, you know, hundreds of them?
Well, in my research in archives in Kew in London and also in Pretoria and here in Australia, I did uncover, particularly in Pretoria, British Army reports about similar conduct by British officers. Memos, reports of conduct similar to this. This is my speculation, but at the time these trials occurred, Kitchener was negotiating a peace treaty. And there was a real fear with the shooting of Hees, the German missionary, that Germany, which helped the Boers with logistic support, Mauser rifles and so forth, may come in the war on the side of the Boers. And the war in Britain had become very unpopular, expensive. You had evidence of concentration camps, the death of women, disease, children. The media got stuck into the British military. So there's a lot of pressure to bring it to an end. And perhaps this was one way of currying some favour with Boer command. It was interesting though, after these men were shot and Witton was sent to prison, the Boer command actually were very active in seeking his release. And they took up their own petition in South Africa to get him out of jail. So there's lots of ins and outs about the case, but certainly, in short, there were rather outrages. And I don't speculate about whether people were guilty or not, but certainly my mantra is when I look at I suppose the best thing I could do was to put my research out to others. Heaven forbid, I don't want to be accused of being biased. So back in 2013, when I was making a documentary for Foxtel, the handout that's on the table over there, it's a 2-page document noting those who support the case. Now, I accept that maybe I've got it wrong. Maybe I've got it wrong. But some of the writers that criticise this case don't mention anything about Geoffrey Robertson, Sir Lawrence Street, etc., and others. An amazing conspiracy if somehow I was able to convince all of these people, Alex Hawke, Jerry Nash QC, even Brendan Nelson, Dr Howard Zelling, former Chief Justice of the South Australia, now deceased, David Denton QC, Alexander Street, Judge of the Federal Circuit Court, Tony Smith, former Speaker of the House of Reps. The list goes on. Tim Fisher, Tim Fisher stands up there in my view as a great Australian. Served in the army himself. All of these people have looked at the material, and I put it to the test in 2014. We did a moot court in the Supreme Court in Victoria. We had counsel for and against, and we ran the evidence. And the two judges, albeit moot court doesn't have any legal standing, but they found that these men hadn't been tried and sentenced according to law. So every time I raise the bar and go that little bit extra, the government finds some excuse to deny it. Geoffrey Robertson, whatever you think of Geoffrey Robertson, he's certainly a leading jurist. Have all these people got it wrong? Have I? Sorry, yes.
Would you like to expound a bit on what you think these vested interests are? I would have thought populism would have made government of the day keen to hold an inquiry, but you seem to think there are vested interests that preclude such a view.
Oh, I think the technicals from Britain are very long. This is just my theory, it could be wrong, but I think there's an embarrassment about the Boer War. I don't think Britain wants to be reminded of the Boer War and the atrocities that occurred, particularly with the concentration camps. Lord Kitchener still holds a revered position in British military history. I don't think British governments want to say, well, we got it wrong.
But the Australian government, in its own right, could set it aside.
That's right, I'll come to that in a second. But I think there are some in the Australian government and some of the institutions within Australia that are partial to the British view. Has anyone actually said that to me? No. Is it in writing? No. But after 10 years, that's the sense I get. The last dot point there, truly, goes to every time I read that, it hits me in the gut. I think to myself, how would you like to be sitting in the modern era, or then, and sentenced without a right of appeal? And in the modern era, of course, you have to have grounds to be able to appeal. These guys had grounds to appeal from Major Thomas, at the very least, to seek mercy, clemency from the King. And of course, the recommendations would be from the Courts Martial would be one of those things that you would push to the King. I didn't find any evidence that the Crown was aware of the recommendations for mercy, because Kitchener's cable to the Secretary for War, Roderick, saying that I'm going to sign off on the execution warrants, didn't say anything about the recommendations for mercy. How could you, I mean, in all seriousness, how could you...
Jim, I may be wrong about this, but I may be wrong about this, but I have no recollection of redress of grievance ever having been available against a decision of a court-martial. Against administrative decisions, yes.
No.
But against the decision of a court-martial?
Well, all I can say is we don't have the transcripts, but I rely heavily on what Witton has to say and the writings of Major Thomas, where he says he tried to lodge a plea for mercy.
Just a question. Was he a bit of an idiot to admit to killing those people?
Yeah.
He could have just shut up,
Yeah.
and then it would have been, probably would have played out very differently.
Possibly.
So why did he say he shot these people?
Because I'm only, again, speculating, but looking at the writings from Witton and Thomas, Morant believed he was lawful in following lawful orders. So if you think of following orders and you believe them to be true, in those circumstances, I'm not talking about the modern era in Afghanistan, I'm talking about 1902, why wouldn't you admit to it? Because that was his defence at the time. His defence was, we believe, and Witton talks about it, that I was following orders, lawful orders.
Conversely, you want to be accused of not following orders, I suppose.
Well, it's a catch-22, because the law at the time was very clear. The maximum penalty for not following orders, maximum penalty I'm talking about, was execution. So you're damned if you do and you're damned if you don't. Sadly, I don't mean to have a go at Thomas, but I think he really struggled in putting a defence together. I think his strongest point was trying to get an appeal. And to be told that you can't use the telegraph to contact the Australian government, I mean, that's just extraordinary stuff. And for these men not to be able to say goodbye to their descendants, I don't get it. What's the fear? What did the British fear? The British feared word getting out, because the Prime Minister at the time did not know of these trials, and when Witton was released, the Prime Minister met Witton when he came back, when he was released, but at the time the Australian government didn't find out. There was question time in the Parliament in April 1902 about this trial, and the Prime Minister at the time wrote through the Governor General, wrote to Lord Kitchener asking for details. The other intriguing thing, I didn't mention it, George Witton was represented while he was in prison by Isaac Isaacs, who later became Australian Governor General and Chief Justice of the High Court. Isaac Isaacs wrote a legal opinion, which I have a copy of, which is very supportive of this case, to get a review. And his petition that he drafted for Witton did the rounds of Australia, and there were about 80,000 signatures to the petition demanding that the British government release Witton, and one of the supporters for that was none other than Winston Churchill, MP. So for someone like Sir Isaac Isaacs, who became knighted, to take up this case pro bono, I went through all of his materials and research to find out a lot more about what Isaacs did, but he was certainly committed to this case. And it worked. Witton was released.
Can I ask,
Yeah, sure.
the outcome that you're ideally seeking now,
Yeah.
is that Australia going back to England and trying to
No.
No.
I'm going to come to that right now.
And I have one other question.
Yeah.
Actually, I'll remember in a minute. You go ahead, sorry.
All right. Now, the original petition also went to the Australian government, and that's what it sought. Petition to the Queen. She wasn't happy. Okay. Or her advisors weren't happy. The House of Representatives motion. Scott Bushveldt, MP from Queensland, really got stuck into this case, and I'm pleased to say that we got the motion into the House. The descendants came to Parliament in 18. That motion stands. The descendants were very happy, but I'd like to take it one final step. And Richard and Beach were at Parliament for that hearing. This, in my view, serious and compelling evidence that some form of redress. I mean, that's what petitions are about. That's how matters are overturned, either on formal appeal or through a petition. Australia's criminal law history is populated by successful petitions in some circumstances. I believe this is one of those cases. Oh, yeah, there you go. Isaac's gets a mention. Now, here's the exciting bit. I discovered that trying to work with the British government wasn't going to work. In fact, they wrote to me saying, don't write to us again. So I kept writing, but the New Zealand precedent is an interesting one. Different facts and circumstances, but there is a parallel. Because New Zealand and Australia are part of the Commonwealth, there is no legal impediment for legislation to grant a pardon, even though the sentences were from a British court-martial. The New Zealand case in World War I, the 5 New Zealand soldiers executed for what they said at the time was cowardice, leaving the battlefield under extreme PTSD. What the Parliament did over there, they appointed a retired judge. He did a full investigation, made a report, tabled it with the government and Parliament, and a New Zealand MP, who I still have quite a bit of contact with, introduced the bill. And that's how the pardons were obtained. So the pardons in that case did not exonerate the men for running off the battlefield. However, when you read the legislation and when you read the report from the New Zealand government, it acknowledges that there was special facts and circumstances about those men leaving their post. I stuck in a quote from Sandy Street, reservist, and I come back to my point. People don't have to agree with what I'm saying, but these opinions of people that have scrutinised the evidence is pretty compelling. And finally, So, what I put to the this current government through Veterans Affairs and the chairperson of the Senate Select Committee is for an independent inquiry, not by a bureaucrat in the Department of Defence. Truly independent. The easiest thing to do, short inquiry, retired judge, review the material, both for and against, and come up with a conclusion like the New Zealand government did. So, conclude the matter. And I can speak on behalf of the descendants, they'll be happy about that. They'll say, right, it's finished. I believe there are some important principles of our Australian values that say that this case should be reviewed. It's got nothing to do with the film. It's all about the evidence. And I hope that before the election, which is almost on us, that we might get something. I can't see why the resistance. I can't see why you wouldn't do it. It's not speculative, it's evidence-based. So that's what I'm pushing at the moment.
And does that decision rest with one individual?
Yeah.
And who is that?
Oh, in government?
Right.
Oh, well, the list is long. Look, it's not so much the ministers, it's the bureaucrats that sit behind the ministers, particularly in defence. In fact, I've got an FOI application in at the moment because I want to have a look at what's been going on between England and Veterans Affairs and Department of Defence. I've had some good signals from the current Minister for Veterans Affairs and also you may not agree with his politics, but I don't agree with some of his politics, but the statement that was made by George Christensen in December last year in the Parliament, which is quoted in the document, reflects his review of the material. And you may not like his other politics, that's fine, and some of them I don't like either, but he's got it right. And I think to get this matter concluded, we need to bring it away from the guys, the girls that write the bureaucrats. It needs to be done by an independent source, preferably a judge that is retired, maybe someone who's had military experience, I would think. Like, that's what New Zealand did. You know, the New Zealanders do great things sometimes, and this is one of them.
On that point,
Yeah.
New Zealand is an isolated incident, or was the same thing done to Brits and Australians and whoever else was there, I don't know, maybe Canadians?
Yeah.
Is that an isolated thing, or is there a case that the British could say, well, we didn't treat them any differently than we did our own soldiers who we shot in the field who ran off?
Yeah, well, I think as far as the Boer War is concerned, there was some preferential treatment given to the British full-time soldiers.
But the New Zealanders were in World War One, weren't they?
Yeah,
So in that
sorry.
case, was it the same applied to other contingents from other countries, including their own people?
There were over 300 men posthumously pardoned from Commonwealth countries,
Right.
with the exception of Australia, because the Morant matter meant that legislation ensured that Australians could serve in World War I under British command, could be tried for military offences but could not be executed. Whereas New Zealand didn't have that requirement, neither did Canada and Ireland and so forth. But there were over 300 Commonwealth soldiers who were civilly executed for cowardice and desertion.
With full trials or somewhere else?
In the field trials, pretty quick, very fast, yeah.
Do you think that you just said that when they went to World War I, the Australians were not allowed to be executed in this way? Is that what you just said?
Yeah,
Do you think that was something to do with this case?
don't know. I'm reluctant to speculate a lot because I'm critical of people that do speculate about Morant and come up with opinion dressed up as historical fact and evidence. So I want to use the same yardstick. I don't want to do it myself. But privately, I have my views about lots of things that happened in the Boer War, and but this one, in my view, passes the test for an independent inquiry. If there was to be a pardon that flows from that, fine. If there's not, bring it to an end for the dissenters. The other thing that an inquiry would do, I think, as identified by people like Geoffrey Robertson, is to highlight the importance, the crucial importance of trial and sentencing according to law, which is as relevant in the modern era as it was back then. I take my hat off to the British. In 1900, they had a fabulous judicial system in the world that existed at the time. And military law, the Army Act, Manual of Military Law, great legislation. Sadly, in this case, it wasn't properly applied.
Sorry, could I ask then, do you think that they were scapegoats of the Empire?
But they were, what, sorry?
Scapegoats of the Empire?
Well, that's what George Witton says. I haven't written a book like George Witton. So he delves into it and says, well, there was an ulterior motive. Maybe, yeah, probably, possibly.
Were there any Boer prisoners shot after this incident? In the
Not that I've come across, no.
Yeah.
No, there were, I've come across evidence of British soldiers being summarily executed by the Boers, and the uniforms stolen and so forth. I've come across evidence of that, but after this, no. It might have happened, but I haven't seen any evidence.
I think the monarchy in the future would be more open to, you know, maybe not intervening is the word, but because when you think about it, the fact that the king wasn't approached at the time and may have been the saving grace of these people, I'm just saying what road you continue to pursue it beyond 2022, because I can see this never going away.
Yeah.
And you get a sympathetic air out of maybe the monarchy going down track. Younger, minds thinking about things, the fairness and
I think that's a good point. I've tried to cover a lot of this in this book that I've written, and really try to pay respect as a military person to a military person and his history. So I think it's achieved that. That's it. Thank you. Any questions?
Yeah, any questions? Just a
Yes.
formal comment.
When they appointed Thomas as defence lawyer, they appointed a proper military lawyer, perhaps it was Thomas was an infantry officer at the time.
Yeah.
Was that done deliberate bias?
Don't know.
By the person appointed? Who was that person who made the appointment of?
The convening authority. But if they hadn't called on Thomas, this is my theory, no evidence, Kitchener would have had to contact the Australian authorities in Australia to say that we've got this trial and we need an experienced military advocate. Now, had he done that, it would have involved the government. And the government would have said, what the hell's going on? So it was coincidental that Thomas was back in South Africa bringing more volunteers. And somehow he got... Yes, he was contacted to say these Australians have been tried. And Major Lenahan from Sydney, who was also a lawyer. So Lenahan speaks to Thomas, and Thomas in his writing says that. So he agrees to he's promoted to Major, and he agrees to act as counsel.
So it could only have been Australian representative, is that right? It couldn't have been English?
Could have been a British lawyer. Could have been a British lawyer, but there were British lawyers on the prosecution side, Major Bolton and others. So, it could have been done that way.
James, just trying to go back into 1902, so I might not get my phraseology right, but was it accepted as a legal order under a banner of reprisal? So you've got orders that generally revolve around attack, defence, treatment of prisoners, etc. Was there a general acceptance that you could give orders in reprisal based on certain events that have happened in a campaign or a battle.
That's what the manual says.
Because that's the bit that centres on me. If you give orders and they're based in a manual, then they are legal. Unless you say, like nowadays, you aren't allowed, you aren't under the law of armed conflict, there are no orders that are legal in reprisal. But I think in 1902, and I'm probably on a stretch of my knowledge here, but I think orders of reprisal were not illegal.
No, well,
There's a nexus there that they weren't illegal, but they were accepted as a part of it.
well, I think you have to take each case on its merits. And the fact is that if you have, let's say you have a British officer from Sandhurst who full-time, trained in military law, an infantry officer, one might say, well, he would have known that it wasn't a legal order. But the manual provided for reprisal. In military law today, there's nothing in military law that says reprisal. It says self-defence, but it doesn't say reprisal. So post-Nuremberg, all that's gone.
So the nexus for me, there is an order coming down which we look at through our eyes, so that's illegal. But back then, if it's in a manual and reprisal, you could see how well I was following orders, because certainly in the book.
Well, that's what Witton says. And he says that that's what Morant said at the trial, and so did Handcock.
So you obey your superior officer, advise the superior officer.
But rather than not being definitive about it, I'm saying, let a retired judge have a look at it. What's the problem? And you'll get some wonderful decisions from a review that will settle these sort of questions.
Positive or negative could be accepted.
Yeah.
I'm curious if there's any record as to what their fellow troopers, after this happened, what was the outcome? Was there any objection or thing that arose from the troopers involved in this unit?
At the trials.
And after?
Oh, after?
Yeah.
Well, all I can say is that
did they continue to field units like this and so on?
Not sure, but all I can say is that the debacle over the hurried executions was addressed by the Australian government at the time. And that tells me something. It tells me that the Australian government weren't happy at the time, were not happy about how these men had been treated. And they were worried about Australians serving under British command in future wars. So the embargo was brought in. You can serve, you can be tried, sentenced, but you can't be executed.
I was wondering if has anyone visited Morant's grave in South Africa. I was told some Australians went there and people wouldn't allow them to look at the grave. And I'm just wondering if anyone here has gone to.
I've been there 3 times.
Have you?
Yeah.
And you just went in there?
Great looking headstone. Now, when we made the Foxtel documentary, Breaking Morant the Retrial, we did filming there.
Oh, good.
And it's a military cemetery, a lot of military graves, predominantly South Africans, but also English and Australians.